right, I'm showing 1:30. You guys ready to start?
Yes, Chairman.
Perfect. All right, we'll get to everyone. Meeting is called to order. Mr. Truman, has anyone signed up for public comment?
Afternoon, Commissioners. We had one registrant, Mr. Cohn. Chuck Cohn, if you're there, go ahead and unmute yourself.
As he is not signed in according to our records.
Okay, that's those that we have signed in today.
All right, thank you, Mr. Truman. Good afternoon, Ms. Miller.
Good morning, sir. Good afternoon, sir.
Yeah, well, it's afternoon. We're trying to get to the end of the day, aren't we?
Yes, sir.
It's hard when we move. We're going to pick up with agenda item 3, but we have no cases to reconsider under agenda item 3. Is that correct?
That is correct, sir.
So we'll move to consider tax liability cases under agenda item 4. And I do think we have one tax case on docket 46.
Yes, sir. It's case number TD-20-074-0520. Commissioner Demerson?
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
Disagree with staff recommendation. Timely motion for reconsideration. Motion for reconsideration denied.
Yes, sir. We'll mark that as a dissent on your behalf. Thank you. That concludes tax liability cases.
All right, under agenda item 5, we have no fair housing cases under agenda item 5.
That is correct, sir. No cases.
All right, and then on agenda item 6, we have one wage claim case pulled for additional discussion on docket 46.
Yes, sir. That is case number 19-060956-1. Commissioner Demerson.
The AT decision is not supportable. The employer missed the first hearing on April 1st, 2020 because the owner's restaurant in Fort Worth was closed due to the pandemic. During that time, pandemic restrictions were at their strictest in Texas. The owner is being faulted because he was able to locate some records and send them in for the hearing, but those could have been records that he just happened to have at his house. He credibly explained that the other important wage claim records were at his restaurant, which he could not access due to the shelter-in-place order in effect. That also meant that the employee witnesses were restricted to their homes dealing with the pandemic according to their own needs. All in all, the employer tried the best that he could under terribly difficult circumstances. We're showing flexibility for claimants who were under pandemic-related restrictions and should do so for the employer on the good cause issue. Accordingly, we should reverse the appeal tribunal decision and remand the case on the merits. The employer had good cause to miss the first hearing, remand to the wage claim appeal tribunal on the merits of the wage claim.
The decision is supportable. The employer received the hearing notice. The employer did not attempt to attend the hearing because they had closed their business due to the pandemic. The employer did not explain why witnesses could not have participated from their homes. The employer did not attempt to contact TWC until after the hearing occurred. The employer has not provided good cause for their non-appearance. The available information supports the original determination. Affirm the AT, no good cause, $420.65 wages owed.
Reverse the WCAT. Employer established good cause for WCAT 1. Resubmit.
All right, one moment, please. We have a majority vote on the good cause issue, but not a majority vote on what to do regarding the merits.
Yeah, I agree with the chairman, and resubmit is fine.
All right, one moment. I'm just checking here to
I had no good cause.
just make final check here. One moment, I apologize.
All right.
There is merits testimony from WCAT 2, but it's not summarized here. So normally we would resubmit at this point.
Ms. Miller, can I short form on the good cause, please?
If we resubmit, there won't be a decision issued yet.
Okay.
Commissioner Demerson, did you want to resubmit and agree with the chairman?
Yes, that's fine.
Okay, that's what we'll do.
All right.
Okay.
All right. That concludes the pull cases under this agenda item. I did forward the wage claim short form dissent list for docket 46 a moment ago.
Yes, and I move we accept staff recommendations on the remaining wage claim cases on docket 46.
I second the motion except for those cases on which I'm dissenting as reflected on the wage claim short form dissent list for docket 46.
I concur with the chairman's motion, except for the cases on which I'm dissenting is reflected in the wage claim short form dissent list for docket 46.
And the motion passes with the exceptions noted.
Thank you.
Let's move to agenda item 7, consideration of unemployment insurance cases on docket 46. Please proceed when you are ready.
Case number 2492116. Commissioner Alvarez.
The claimant has provided sufficient evidence to establish good cause. The claimant was away from home assisting her ill and elderly mother to reduce her mother's exposure to the virus. The claimant was not the appellant and had no reason to expect a hearing was going to occur. The claimant had good cause for her non-appearance. If my fellow commissioners do not believe that the claimant has established good cause, the case should be reheard to take additional testimony regarding the claimant's own medical appointments that prevented her from attending the hearing. Even if the claimant did not have good cause and this case is not reheard, the available evidence establishes the claimant should be entitled to benefits. The claimant was discharged for failing to complete 300 tasks in a month. The employer admitted the claimant had never been able to complete 300 tasks in a month during her employment. The claimant's inability to perform to the employer's satisfaction is not misconduct connected with the work. Reverse the AT good cause and resubmit for merits.
The AT decision should be affirmed. On good cause, the claimant was advised that the employer could appeal. However, she left town for several weeks without changing her address with TWC, forwarding her mail, or assigning anyone to check her mail in her stead. Regardless of the reason for her absence from home, the claimant missed the hearing because she did not take any steps to ensure timely notification of TWC correspondence. Consequently, a rehearing is unnecessary and the claimant did not establish good cause for her non-appearance. On the job separation, the claimant was on final warning when she reasonable instructions from management. Based on the claimant's various attendance issues, including taking extended lunches and clocking out early, the record supports a conclusion that the claimant's attendance contributed to her poor performance. As such, the claimant's discharge was due to misconduct and we should affirm the AT decision. The claimant did not have good cause for a non-appearance, misconduct, no chargeback, adequate employer response.
Reverse the AT. Claimant established good cause for AT1. Resubmit.
All right. We have a majority vote that the claimant established good cause and a majority vote to resubmit. All right. We will resubmit this case.
Case number 2501270. Commissioner Alvarez.
The decision should be modified. I agree that the employer should be granted good cause because it cannot be confirmed that the notice packet was remailed with proper notice under Rule 16(1)(b). With regard to the job separation, the claimant was discharged for allegedly spending too much time off task. The claimant testified that he was unwell on the night in question and took a number of bathroom breaks. Other than the bathroom breaks, the claimant has consistently maintained that he was working on the night in question. The claimant has no history of time off task violations. The employer failed to produce any firsthand witnesses to contradict the claimant's sworn testimony. The employer also failed to produce any records regarding time of task. The employer's evidence fails to establish misconduct connected with the work. Modify the AT. Employer had good cause for its non-appearance, no misconduct, chargeback.
The AT decision should be reversed. On the good cause issue, the original hearing notice was returned to TWC for lack of postage and had to be remailed out. This caused the delay in the employer's receipt of the notice and left the employer with insufficient time to arrange for a proper witness to be present at the hearing. Circumstances related to the pandemic further prevented the employer from acquiring a witness to participate. Based on this evidence, the employer's failure to appear occurred due to circumstances beyond its control, and the petition to reopen should be granted in the interest of justice. As to the merits, the claimant was discharged for incurring over 136 minutes of unexplained time off task while at work. The claimant's restroom breaks were deducted from his time, yet he still exceeded the allowable amount under policy. Thus, I would not agree to an MVI in this case. Since the claimant was aware of the employer's policy and knew that his job was in jeopardy, misconduct was established. We should therefore reverse the AT decision. The employer had good cause for its non-appearance, misconduct, no chargeback, adequate employer response.
First, the AT, employer established good cause for AT1. Misconduct, no chargeback, adequate employer response.
Short form dissent.
Yes, sir, Commissioner Alvarez, I have your dissent.
Case number 2513950. Commissioner Alvarez.
The AT2 decision should be modified. I do not dispute the ruling on the good cause issue. However, based on the evidence before the AT1, the underlying reporting ineligibility should be reversed. The claimant was asked to report during the time period in which it would have been impossible for the claimant to do so because of the overwhelming number of individuals attempting to contact the commission to file for UI benefits. Moreover, the claimant has since provided the required documentation to establish work authorization, which was what was necessitated the original request to report. The claimant's fact-finding statement taken in September 2020 indicates that he was unable to get through to the agency to report as requested. The claimant's failure to report was not through any fault of the claimant. Modify the AT, no good cause for the claimant's non-appearance, reporting ineligible. Correction, reporting eligible.
The AT decision should be affirmed.
Necessitated.
The claimant's misreading of the hearing notice did not provide him with good cause for his non-appearance. The reporting issue, the available evidence supports that the claimant failed to report to TWC in a timely manner as instructed. Thus, the ineligibility, which was subsequently closed, is appropriate. Accordingly, we should affirm the AT decision. The claimant did not have good cause for his non-appearance, reporting not eligible, beginning April 5th, 2020, and leave in effect the closure date of September 12th, 2020.
Modify the AT. Claimant did not establish good cause for AT1. Reporting ineligible April 5th, 2020 through May 2nd, 2020. Void the September 14th, 2020 closure determination.
All right, we have majority vote on no good cause for missing the prior hearing. We do not have a majority vote on the reporting issue, specifically the closure date. Commissioner Demerson?
Sure, let me discuss with council real quick, all right?
Certainly, thank you.
Ms. Miller, I would agree with the chairman on the closing date.
Very well, I'll mark your vote as agreeing with the chairman.
Now, short form dissent on that, the closing date.
Boy, that was a hard word.
All righty, short form dissent, Commissioner Demerson.
Thank you.
Case number 2531919. Commissioner Alvarez.
The decision is not supportable. After the claimant went on FMLA and filed her claim, she received unexpected payments from the employer, which were classified during the hearing as COVID-19 pay. One of the employer's witnesses also indicated the pay the claimant received was related to payment for sick and vacation time. This case should be reheard to clarify the nature of the payments.
The AT decision is supportable under the Texas Supreme Court 2018 decision in Texas Workforce Commission versus Wichita County 548 SW 3rd 489. The claimant could file an unemployment claim while on FMLA leave, but as that court held, the claimant would need to meet the definition of unemployed and not be in paid FMLA leave status. The evidence shows that the claimant was on full pay status during the first 2 weeks of her FMLA leave. Thus, she did not meet the definition of an unemployed individual during the time she was receiving a regular full-time pay. However, after that time, she could be considered unemployed under medical or disaster-related circumstances. Accordingly, we should affirm the AT decision. The claimant was not unemployed when she filed her initial claim and sent a memo to UIO and CS regarding whether the claimant may file a corrected backdated initial claim.
Reverse the AT, valid claim, no misconduct, no chargeback, disaster.
All right, we have three very different votes. Commissioner Alvarez?
Mm, I will agree with the chairman.
Very well, thank you.
Yes, ma'am.
All right, and we'll short form dissent on that one.
Yes, sir, Commissioner Demerson, I have your dissent.
Thank you.
Case number 2576402, Commissioner Alvarez,
The AT decision is not supportable. The claimant was furloughed during the week of March 29th. She attempted to file an initial claim at the time, but could not get through to file the claim. The claimant did not file an initial claim until April 28th because she was unable to file the claim due to the technical difficulties the commission experienced as a result of the pandemic. The claimant established good cause for her initial claim to be backdated. Reverse the AT, backdate the claimant's initial claim to March 29, 2020, and authorize her to file a backdated payment request for that claim week.
The AT decision was basically supported since she was employed when she filed her initial claim, but I believe that the claimant has shown good cause for backdating that claim. The claimant testified that she attempted to have her claim backdated, but could not get through on the phone lines at the time, which was in late April 2020. During that time, the agency was advising the public that it would grant backdating of claims whenever possible and appropriate. Her inability to reach TWC was understandable, and so I would be in favor of allowing the claimant to backdate her claim to the week during which she was unemployed due to the pandemic.
I would concur with Commissioner Demerson.
All right, Commissioner Demerson, do you agree with the date provided by Commissioner Alvarez, backdating to March 29th, 2020?
March 29th, in the week when she was unemployed. Let me check real quick.
Yes, sir.
All right, sure, we agree with Commissioner Alvarez with that date. We're fine.
Thank you. Backdating to March 29th, 2020. And we have a unanimous decision. Thank you.
case number 2580413, Commissioner Alvarez,
The AT decision is not supportable. The testimony from the employer established that the claimant at the time of her separation was working 4 or 5 days per week. She stopped working due to COVID-19, and the employer then paid her wages equivalent to about 2 days of work per week. She therefore had a reduction in hours and filed a valid claim. The separation was due to the pandemic and therefore not disqualifying. Reverse the AT, valid claim, no misconduct, bill reimbursing employer. Even if it was concluded that the claimant did not have a reduction in hours, she was clearly a partially unemployed individual who filed a valid claim. In section MS 510.00, Appeals Policy and President Manual, in appeal number 39676-AT-66, that President holds that the claimant who is employed in regular part-time work and has not been separated from this work cannot show this work as her last work on her initial claim, since there has been no separation. A claimant must show the last work from which she was separated prior to her initial claim. In this case, the claimant worked for the employer for 5 years as a substitute teacher, and her last separation before March 2020 was almost certainly from the same employer at the end of the school term or a school break. If it is concluded that she did not have a work separation in March of 2020, the case should be reheard to determine whether the claimant is qualified for benefits based on her last work separation from the employer.
The AT decision is supportable. The claimant was on regular pay status when she filed her initial claim during her COVID-19 related shutdown of her school. And she in fact likely received more than her usual pay while out on COVID-19 leave. Unemployment benefits are not for individuals such as the claimant who are on full pay status. She filed a new initial claim in early June 2020 following the end of the school year and should be entitled to have her claim certifications for periods after that time carried over to her new initial claim. Although the employer may not have been a party of interest, validity of claim issues may be considered at any point during the benefit year, and the appeal tribunal had jurisdiction to consider that issue. Accordingly, we should affirm the AT decision. The claimant was not unemployed when she filed her initial claim, invalid claim, void the reimbursement ruling, and send a memo to UIO and CS regarding transfer of her claim certifications to the new initial claim.
Affirm the AT invalid claim, void the separation and reimbursement determination.
Short form dissent.
Yes, sir, Commissioner Alvarez. And we'll send your memo, Commissioner Demerson.
Thank you.
Case number 2582708. Commissioner Alvarez,
The decision should be modified. The claimant was on approved leave of absence. The claimant was unable to return to work as scheduled due to COVID. The claimant was laid off due to the disaster. Modify the AT, no misconduct, no chargeback, disaster, sever validity of claim. Validity of claim.
The AT decision should be modified. The claimant had a good personal reason for quitting. However, none of the exceptions to disqualification provided for under the Act may apply to this case. I agree that the separation was urgent, compelling, and necessary, since the statute requires the reason for quitting to be work-related, which it is not. Furthermore, there is no indication that a minor child of the claimant was involved, so I would not agree to an MBI. There is also insufficient evidence that the claimant was laid off due to the disaster. The claimant resigned without connected good cause, and we should modify the AT decision. Voluntary leaving, no chargeback, sever validity of claim issue.
Rehear the case on all separation issues, including FMLA, return to work date, and employer's letter laying claimant on.
I agree with the chairman to rehear.
We will rehear the case.
case number 2585518. Commissioner Demerson,
The employer's MR should be granted. Both parties mentioned the floor manager in connection with critical details of this case. However, it does not appear that the employer was asked if the floor manager was available to testify. The employer states in its MR that the floor manager is willing to provide testimony. As such, we should grant the employer's motion for rehearing for testimony from the floor manager.
The MR should be denied. The employer is offering to provide additional witness testimony. However, the employer's MR did not provide any reason for not providing this witness sooner. As the employer did not provide a compelling reason for not offering the witness earlier, the MR should be denied. Deny the employer's MR.
Deny the motion for rehearing.
I'll maintain my previous dissent, Chair.
Yes, sir, Commissioner Demerson.
Thank you.
case number 2589442. Commissioner Demerson,
The appeal tribunal decision should be modified only to reflect that the claimant filed a timely appeal. The job separation ruling is supportable. The claimant stated that he was not discharged and accepted a voluntary early retirement package. Accordingly, the case was properly analyzed by the appeal tribunal under 207.045 of the Act, having to do with voluntary leaving. The claimant did not say he was told that he would be laid off or terminated if he failed to accept the voluntary retirement package. As such, the claimant quit for the personal reason of taking a voluntary retirement package, which is without good cause connected with the work. We should therefore modify the AT decision, timely claimant appeal, voluntary leaving, no chargeback. But in the alternative, if my fellow commissioners are not yet convinced that the claimant quit without work-connected good cause, we should rehear the case to ask the claimant whether he had the option of continuing to work if he had rejected the voluntary retirement package, and whether he was notified that he would be laid off or terminated if he failed to accept the package.
The decision should be reversed. Regarding the timeliness issue, the claimant began to sign up for electronic correspondence, but did not complete the process. Therefore, the determination should have been mailed to him, but it was not. The claimant tried to call TWC numerous times, but could not get through to resolve the issue. As the determination was not mailed to the claimant's correct physical address, the claimant's appeal should be deemed timely. Regarding the job separation, the greater weight of the evidence indicates that the claimant would still have been laid off if he had not accepted the offered package. The claimant testified that he was personally aware of the employer's financial situation and that the thousands of employees, including employees with 20 years of service like himself, were laid off. As the claimant would have been laid off anyway, accepting the offered package was not disqualifying. Reverse the AT, timely claimant appeal, no misconduct, chargeback.
Modify the AT, timely claim and appeal, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2591682. Commissioner Dimerson,
The appeal tribunal decision should be modified. I agree the claimant filed a valid claim. As to the job separation, the employer stated that the claimant became irate when asked about taking the temperature of food product and proceeded to throw things around the kitchen. The employer also stated that the workers and customers witnessed this incident. The claimant admitted that she became frustrated with the employer's questions and that she tossed a metal spatula into a metal sink. While a claimant may respond unenthusiastically in the face of a reprimand, doing so in a manner described by the employer rises to the level of misconduct connected with the work. We should therefore modify the AT decision, valid claim, misconduct, no chargeback, adequate employer response.
The decision should be affirmed. The owner and the claimant disagreed about the proper way to check the temperature of food. The claimant believed that she was following correct food safety measures and that the employer was trying to take shortcuts. In response to the disagreement, the claimant tossed a spatula in the sink. As the claimant did not have any prior warnings, her act of tossing a spatula into the sink did not rise to the level of misconduct. Affirm the AT, the claimant filed a valid claim, no misconduct, chargeback.
From the AT, valid claim, no misconduct, chargeback.
Short form.
Yes, sir, Commissioner Dimerson.
All right, thank you.
case number 2595694. Commissioner Alvarez,
The decision is not supportable. In case 2567783 on docket 43, the commission found that customary full-time hours was a validity of claim issue and was entitled to the timeliness exception rule in Rule 32I1. Accordingly, the claimant's appeal should be deemed timely and resubmit.
The AT decision should be reversed because this case involves the underlying issue of customary full-time hours, which is tied to validity of claim issues. Claimant's appeal should fall under the one-time exception to the timeliness rules. As such, the claimant's appeal should be deemed timely and the case remanded. We should reverse the AT decision, timely claimant appeal, remand.
Reverse the AT, timely claim and appeal, resubmit.
Chairman, if I may interrupt before Ms. Miller goes on to the next case, I had asked earlier if I could take a 5-minute break to get
Yeah.
off and do something really quick, and then if
Of
we
course.
could resume.
Ms. Miller, do you have everything you need on this pull 11?
Yes, sir. We have a timely appeal and resubmit.
All right, we're gonna take a 6-minute recess so that Commissioner Alvarez can take care of some pending business, and then we'll resume when he returns.
Thank you, Chairman.
Thank you.
Thank you, Chairman.
Oh, it's my pleasure. Thank you. All right. Let's resume. Ms. Miller, let's pick up where we left off.
Yes, sir. It's the 12th case, case number 2597700. Commissioner Alvarez.
Yes, ma'am. The claimant ceased working for the employer on March 20th, 2020, when he was instructed to make an unpaid 2-week self-quarantine due to experiencing pandemic-related symptoms. The claimant continued experiencing symptoms after the quarantine period was over. The claimant was separated at the time he was placed on unpaid leave due to his illness. Since the claimant's separation was related to an illness and the claimant should be qualified for benefits in the employer's account protected from charge. Modify the AT, valid claim, no misconduct, chargeback, MBI.
The appeal tribunal decision should be modified. The claimant quit his job due to COVID-related reasons. However, the employer stated that it had multiple signs that COVID testing was free at certain locations. In addition, the claimant failed to request a leave of absence from the employer and instead quit his job. Moreover, the employer stated that it provides masks, gloves, and sanitizers to the store frequently. The employer also stated in its appeal that work was available. As such, the claimant quit for personal reasons and without work-connected good cause. We should therefore modify the AT decision, valid claim, voluntary leaving, no chargeback, adequate employer response.
Reverse the AT, valid claim, voluntary leaving, no chargeback, adequate employer response.
Short form dissent.
Yes, sir, Commissioner Alvarez. And I verify that Commissioner Demerson and the chairman's votes do agree, even though one said modify and one said reverse. The votes do agree.
Thank you, Chair.
Thank you. Next case, please.
Sorry about that. 2601458. Commissioner Alvarez.
The decision should be reversed. The claimant is an independent contractor who makes commission only from services she provides as a nail technician. The claimant only earns money if there are actual customers. The salon might want the claimant to be present at the booth that she rents, but no evidence has been presented that there were customers seeking her services in the middle of the pandemic. Given the claimant the opportunity to be at her booth is not the same as establishing that there was actual work available. The evidence fails to establish that an offer of suitable work was made. Reverse the AT, no offer of suitable work, no overpayment.
The appeal tribunal decision should be affirmed. The evidence indicates that the claimant was offered the same job she had prior to her separation, so the offer of work was suitable. The claimant chose not to return to work for personal reasons. As such, the claimant did not establish good cause for rejecting the offer of suitable work, and we should affirm the AT decision. Suitable work disqualification, overpayment of $1,242.
Reverse the AT, no suitable work disqualification, no overpayment.
Short form.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2605974. Commissioner Alvarez.
The decision should be modified. The claimant's testimony regarding the file in February were inconsistent, but the claimant has consistently maintained that she attempted to file in May when she was separated from her employer a second time. The phone lines were overwhelmed in May. The initial claim should be backdated to May 10, 2020. Modify the AT, valid claim, backdating to May 10, 2020, allowed. Customary full-time hours not eligible, 8/2/20 to 8/8/20.
The AT decision is partially supportable. The claimant did not show a good reason for failing to file her initial claim back in February. Her initial claim fact-finding statement did not agree with the commission appeal regarding what she was allegedly told by the TWC concerning the time to wait to file a claim. However, she plausibly explained that after she lost the subsequent period of employment in early May 2020, she had significant trouble contacting TWC. I support allowing the claimant to backdate her initial claim to the week in which she lost that job. Concerning the customary full-time hours issue, The evidence shows that the claimant worked a full 40-hour per week schedule during the first benefit week of August 2020. So she was properly held to have been not unemployed during that week. My fellow commissioners feel that the claimant has shown good cause for backdating her claim to February 2020. We should send a memo to UIO and CS to investigate her medical ability to work during the periods that she testified she was too ill to work. Accordingly, we should modify the AT decision. The claimant did not show good cause for backdating an initial claim to February 2020. Allow backdating starting with the date of her May 2020 work separation, and the claimant worked her customary full-time hours from August 2nd through 8th, 2020.
Can you read to me Commissioner Alvarez's vote?
Commissioner Alvarez, according to my notes, voted that the claim should be backdated to May 10th, 2020, and the claimant was properly ineligible for customary full-time hours, August 2nd through August 8th.
I'll concur with Commissioner Alvarez.
Thank you.
I concur with that as well, Sharon.
We have a unanimous decision. I appreciate it, gentlemen. Thank you.
Case number 2607056. Commissioner Alvarez.
The AT decision should be reversed. The claimant needed to leave work early because the child of a close family friend was in a coma after surgery. The claimant requested permission to leave early, but the request was denied with no explanation. The claimant had PTO available to cover her leave. No evidence was presented of a history of excessive absenteeism or warning of absences. The employer has offered no explanation why the claimant's request was denied. Based on the evidence presented, the employer made an arbitrary decision to deny the claimant's request, and her decision to leave work did not constitute misconduct connected with the work. Reverse the AT, no misconduct chargeback.
The appeal tribunal decision should be affirmed. The claimant asked for half a day off to attend to a personal matter. The claimant was denied that time off. When instructed to take her lunch, the claimant refused, remaining steadfast in her intention to take a half day off despite being barred from doing so by the employer. The claimant was then discharged. Between the claimant's refusal of taking her lunch and representing that she had intent to disobey the employer's instructions by taking half a day off, the claimant's behavior fell squarely in the realm of insubordination, which amounted to work-connected misconduct. We should therefore affirm the AT decision, misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2607638. Commissioner Dimerson.
The appeal tribunal decision is fully supportable. The claimant was discharged for not following the employer's ticketing procedure. The claimant admitted in testimony that he failed to follow the employer's procedure and that he knew his actions could lead to discharge. Because the claimant was on final warning, his non-performance of his job duties constituted misconduct connected with work. We should therefore modify the AT decision, misconduct, no chargeback, sever adequate employer response.
The decision is not supportable. The claimant was the only party to provide firsthand testimony, and it should be given greater weight. The claimant was discharged for failing to follow the proper ticketing process. The claimant was unable to follow the process because the employer was understaffed, and he had to assist other employees. The employer did not refute the claimant's allegations that were understaffed. They were understaffed. The claimant had expressed the understaffing issue to the employer and informed the employer about areas in which he lacked training. The claimant's failure to follow the policy was due to circumstances outside his control and not misconduct. Reverse the AT, no misconduct, chargeback, set aside adequate response.
Reverse the AT, no misconduct, chargeback, void adequate response.
And Commissioner Dimerson, did you say short form dissent? Yes, sir. There's a little bit of skipping in your audio.
Okay.
Case number 2607783. Commissioner Dimerson.
We should reverse the appeal tribunal decision. And you gentlemen, you're hearing okay, right?
Yes, sir.
Good. We should reverse the appeal tribunal decision. According to statute, a reimbursing employer's liability is not based on a claimant's qualification for benefits. per section 205.0125A2 of the Act, a reimbursing employer is not liable for paying a reimbursement, regardless of whether the employer was named as the individual's last work. If the individual's separation from work resulted from the individual voluntarily leaving work without good cause connected with the work. Here, the claimant quit her part-time job for full-time work. Even though the claimant's situation may fit one of the enumerated exceptions to the disqualification under section 207.045 of the Act, leaving one job for another is a personal reason for quitting, not good cause connected with work. Therefore, because the claimant quit for a reason that did not constitute good cause connected with the work, the employer should not be billed for benefits. We should reverse the AT decision, reimburse an employer not billed.
The AT decision should be affirmed. The claimant worked part-time for the employer, and she quit the job in order to accept a full-time job with another employer. Because the claimant quit her part-time job for a further position that she reasonably believed would increase her weekly wage, the claimant would not have been disqualified under section 207.045G of the Act if this had been her last work separation. Since the claimant had good cause connected with the work to quit, the employer should be billed for benefits. Affirm the AT, bill, reimburse an employer.
Reverse the AT, reimburse an employer, not bill.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2610875, Commissioner Dimerson.
We should reverse the appeal tribunal decision. The employer's sworn testimony in his documentary evidence established that the claimant was required to maintain regular contact with the employer after the end of an assignment. By applying the home health care precedent, the job separation was initiated by the claimant when she failed to call the employer as instructed. Her actions communicated to the employer that she was no longer interested in working and effectively severed the employment relationship. In the absence of testimony from the claimant, there's no evidence that she had good cause connected with work for quitting. Thus, because the claimant initiated the job separation without work-connected good cause, we should reverse the AT decision, voluntary leaving, no charge back, adequate employer response.
The AT decision on the work separation should be affirmed. The claimant stopped working on her assignment because her client left town. The claimant immediately contacted the employer for another assignment, but no further assignment was available. The employer did not, therefore, attempt to place the claimant on another assignment. Since the claimant communicated to the employer her desire for another assignment and was never offered further assignment, the claimant was involuntarily separated under non-disqualifying circumstances. Modify the AT, no misconduct, chargeback, void, adequate response rule.
Modify the AT, no misconduct, chargeback, void, adequate response.
Short form.
Yes, sir, Commissioner Dimerson.
Case number 2615924, Commissioner Alvarez.
The decision should be modified. The claimant was 7 months pregnant, and she stopped working due to the risk that COVID-19 posed to her unborn child. The claimant provided medical documentation confirming that the doctor recommended that she quarantine due to the increased risk. The claimant had good cause connected with the work for leaving. Modify the AT, no voluntary leaving, disaster, void, chargeback.
We should affirm the appeal tribunal decision. The claimant quit out of fear of contracting COVID-19. The claimant's doctor had not advised her to quit, nor was the claimant experiencing any symptoms requiring her to quarantine. In addition, the claimant agreed that the employer provided PPE and took precautions against the virus. Although the claimant had submitted medical documentation, it is dated 6 weeks after the claimant decided to stop working and would have played no part in her decision to quit. Under these circumstances, and in line with recent decisions from the Commission, quitting work solely out of fear of the virus does not provide the claimant with good cause connected with work for quitting. Accordingly, we should affirm the AT decision, voluntary leaving, void chargeback.
Affirm the AT, voluntary leaving, void chargeback.
Short form dissent. And also, Ms. Miller, if I could have a memo to investigate PUA eligibility.
Yes, sir, I have a short form dissent and memo to investigate eligibility for PUA.
Yes, ma'am. Thank you.
Thank you.
Case number 2619568, Commissioner Alvarez.
The decision should be reversed. The claimant testified that he turned down work because he lives with his elderly parents who have underlying conditions consistent with the suitable work guidelines approved by the commission on June 16, 2020. Living with a household member at high risk for COVID-19 constitutes an acceptable reason for refusing suitable work. Reverse the AT, no offer of suitable work qualified.
We should affirm the appeal tribunal decision. The employer offered the claimant work which was in line with his previous duties, with the same number of hours and the same pay. Furthermore, the inconsistencies and contradictions in the claimant's settlement statement to GWC cast serious doubts on the evidence he provided. Because the preponderance of the credible evidence established that the claimant first ignored and ultimately rejected an offer of suitable work because there was no upside to returning to work, the claimant should be disqualified from the receipt of benefits. We should affirm the AT decision. The claimant refused an offer of suitable work.
Affirm the AT, suitable work disqualification.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2620694, Commissioner Alvarez.
The decision is correct and there is sufficient evidence in record to overturn the decision. The claimant was contacted by the employer and informed of their reopening plans. Under the employer's plan, the claimant would have been in close contact with the general public in confined spaces. The claimant was unable to return to work under the employer's plans because his wife has a medical condition which makes her at high risk should she get COVID-19. The claimant informed the employer he could not return and offered to work in a capacity that did not interact with the public. In accordance with Commission guidance dated June 16, 2020, the claimant's reason for rejecting the work should be not disqualify him from benefits. The resulting overpayment should be reversed as well. Reverse the AT, suitable work, eligible, no overpayment.
We should remand this case to the appeal tribunal. Because the claimant offered relevant documentary evidence that was not reviewed at the hearing, we should remand this case to the appeal tribunal for review and consideration of this evidence.
Reverse the AT, no suitable work disqualification, no overpayment.
Short form.
Yes, sir. I have your short form dissent, Commissioner Demerson.
And Sherry, let me also just ask, based on the claimant's testimony and documentary evidence, we should send a memo to UIO and CS to indicate the claimant's availability for work.
Yes, sir. Memo on availability to work.
Thank you.
And that was the last UI case pulled for additional discussion on docket 46. I did send the short form dissent list for docket 46 earlier in the meeting. Thank you, gentlemen.
And I move we accept staff recommendations on the remaining UI cases on docket 46.
Chairman, I second the motion except for those cases on which I am dissenting as reflected on the UI short form dissent list for docket 46.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected by short form dissent list for docket 46.
Motion passes with the exceptions noted.
Thank you very much.
Thank you. And this brings us to the end of agenda items 3 through 7. Let's pause for a moment to reset for the rest of the meeting. All right, here we are. Let's pick back up with agenda item 8. This is acceptance of pledges and child care matching funds, but staff has nothing to report for this item. Agenda item 9, the skill development fund effectiveness report is being postponed to a future meeting. This brings us to agenda item 10. This is the overview and discussion of the Tri-Agency 2020 report as submitted to the Office of the Governor.
Good afternoon, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Serna. For the record, Carrie Ballast, Workforce Development Division. As you are well aware, the Tri-Agency Initiative is a partnership formed across Texas Workforce Commission, Texas Education Agency, and the Texas Higher Education Coordinating Board. The initiative dates back to 2016 and has served as a powerful setting in which the three agencies come together to coordinate activities geared towards alignment and success of education and workforce initiatives. In February of 2020, Governor Abbott issued a new set of charges for the tri-agency partners. And since then, a work group made up of representatives from the three agencies have met at least once a week to create a report in response to those charges and to plan for the future work. That report, which was published via a website, was made public yesterday afternoon at triagency.texas.gov. The report reflects extensive stakeholder input gathered through virtual meetings and surveys and provides details on how the three agencies propose to meet the governor's charges. The report is organized under 3 priorities, and I would say these will be our 3 North Stars for the next few years: pathways, support, and infrastructure. And the report also provides details on how those 3 priorities will be addressed. With the launch of the website, the first round of this very important work is now complete. And so it is now time for the second round, in which the 3 agencies will roll up their sleeves to expand our current work and to begin new work. It is at this action level that other divisions and departments will develop work plans tailored to our diverse customers. These work plans will be published on the website at a later date. Another step in the development is the development of metrics by which agencies will measure and report progress towards meeting the tri-agency charges. These metrics will not only enable us to measure our progress, but also will allow our stakeholders to see where we are headed and how we are doing. TWC staff welcome the opportunities to work with each of your offices to ensure that our customers' needs and goals are kept front and center in our work. We see the strong, undeniable connection between education and workforce and look forward to the work ahead. I'm available to answer any questions you may have, and thank you.
Thank you. Questions or comments?
Chairman, I have some comments. First of all, I wanted to thank Ms. Ballas for continuing to meet with the other 2 agencies and to inform the offices of what's been going on and the progress that they've made. And then I also wanted to take this opportunity to thank you, Chairman, for taking the lead and for everything that's in the report. We've read it a few times. It's a really good report. So thank you for taking the lead on that. And the only question that I have, so Carrie, thank you and your team, and of course, Chairman, thank you as well. The only question that I have is, we don't have a physical report. So I'm assuming, even using the word report is a little, we gotta be careful. It's on a website. Right. Is that available for us to download so that if someone wants to see it as we go around the state and promote what we did in 2016, published in June, do we have an opportunity to download this website informational stuff so that we could inform employers or claimants, customers of what we're doing?
Yes, sir. We do see that having a downloadable version of this will be very helpful for many of us. I do not believe it's available yet, but it is one of the next steps, and you will see it on the website very soon. I'll make sure to notify you when
Great.
That is available.
And again, Ms. Ballas, thank you for your hard work and for working so closely with all 3 offices. So thank you for that.
It was my
Again,
pleasure.
thank you, Chairman. Thank you and your team.
Chairman, I'd also like to thank Carrie and the team for the work they're doing on this. I was around when we did Tri-Agency 1.0, and now we're at 2.0, and we're taking it to even higher heights and the like. And so I look forward to promoting and supporting the recommendations and partnering with those employers that are out there to make sure that we're listening to their needs and addressing what we need to for that future talent pipeline. Thank you for the work.
Thank you.
Got it.
Ms. Bellis, thank you so much for coordinating these efforts on part of the agency. This was a difficult task, given the circumstances at hand. You guys, I know it was a team of people. You're the spokesperson today, and so please pass along my gratitude to everyone who worked on it. Challenging times, excellent outcomes for some very in-depth discussion items. Commissioner Alvarez, thank you very much for your words of gratitude and encouragement. I appreciate that very much as well. Commissioner Demerson, this will help us chart a course for the next at least couple of years. But understand that TWC leads in our space, and we will continue to do so. This particular report really serves as our link to two agencies that we really must work closely with for the state to be successful. And so, given the times we're in, given the limitations we had on working on the report, I think the website really came out very, very well. I think it's going to be a great place for us to put information that we have right now, and certainly a place for us to memorialize our plans for the future. And so for all involved, thank you very much. I think we've got a great product to show, and I think we've got a nice roadmap to bring us into what I hope will continue to be a very successful future.
Thank you, sir. We look forward to the work. Thank you.
Thank you. All right, we'll move on to agenda item 11, which is statewide initiatives, but staff informs me they don't have anything to present for agenda item 11. For agenda item 12, do we have anything for that, Mr. Cerna?
No, sir, we do not.
All right. How about agenda item 13, discussion, consideration, and possible action regarding approval of local workforce development board nominees?
Good afternoon, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, Shanta Williams with the Workforce Development Division. And before you for consideration are workforce board nominations for Workforce Solutions, Concho Valley, North Central Texas, Greater Dallas, and North Texas. Staff recommends that all nominees be approved, and I'm here to answer any questions you may have.
Any comments or questions?
None here, Chairman.
None.
All right, do we have a motion on this item?
Yes, sir. I move that we approve the board nominees for Concho Valley, North Central Texas, Greater Dallas, and North Texas.
I second that motion.
So moved and seconded, we're unanimous. Thank you.
Thank you.
Agenda item 14, legislative proposals. Staff does not have anything to present for this item.
No, sir.
Legislative report today. Mr. Cerna, do we still not have an executive director's report today? We're good.
There is no executive director's report today.
Thank you very much, Mr. Cerna. Is there any other order of business to come before the commission today?
No, sir.
None? Do we have a motion?
None here, Chairman.
Chairman, I'd like to congratulate Bonnie Downs on my team for celebrating 10 years of employment in state government. So Bonnie's a veteran and communications director here, and I want to congratulate her on reaching that 10-year milestone.
I will join you in that. Congratulations.
Thank you.
Very good.
Any other items? How about a motion to adjourn?
Chairman, you got it. I move that we adjourn, and I'll see you in 30 minutes.
I second the motion. All right.
It's been moved and seconded to adjourn, and we are adjourned. Thank you, everybody.
Thank you,
guys.
sir.